You're listening to Bona Fide Needs, Season 3, Episode 4. Welcome back to Bona Fide Needs. I'm Bill Olver, Managing Editor of the PubK Group. In today's episode, Mike McGill and Naomi Hartman are taking a close look at the Corporate Transparency Act. Enacted in 2021, the CTA requires corporate entities, including LLCs, to report more ownership information to the government. The act is intended to combat illicit activity, money laundering, and financing for terrorism. So what does that mean for federal contractors? Naomi Hartman is a partner in the Corporate and Finance Group at Arnold & Porter. Her practice is primarily focused on helping private equity firms and other entities acquire government contractors. She and Mike discussed the background of the CTA, what Congress intended, and the practical impact on U.S. companies, including federal contractors.
Hey, Naomi, welcome to the podcast.
Hi, I'm so happy to be here. I've always wanted to be podcast famous. So this is my first podcast ever. So I'm happy to be doing this with you.
Well, we're very, very happy to have you. And so we're going to focus today on an issue that I know has gotten a lot of attention it's certainly not an issue that's exclusive to government contractors, but it's gotten a lot of attention within the government contractor community, especially among small businesses. And that's the Corporate Transparency Act. And you're an expert on the Corporate Transparency Act, the CTA. And so perhaps we're going to, I think, kind of do a bit of the ABCs of the CTA today and talk about some of the important implications for companies. And so maybe just to start, what is the CTA? What's the sort of basic background of the law?
So the Corporate Transparency Act, it's a federal law that establishes federal reporting requirements for many U.S. companies. So to your point, Mike, this pulls in companies in all industries all across the country, but it does have particular implications for companies that are active in the government contract space. The law pulls in corporations and LLCs and other entities that have been legally formed within the United States. The overlying policy behind the CTA is to combat money laundering, tax fraud, and other illegal activity in the United States. So I always use this example as my classic illustration of how this works from a layperson's perspective. So an LLC buys a multi-million-dollar condo in New York or Miami or Los Angeles. This is a common practice, and not all individuals want to be on public records or in the real estate title records showing that they are the owner. So I think of reality real estate shows, which I am an expert in the reality TV genre. And the example that I always use is that there's a celebrity who wants to buy a house, and they don't want their personal information out there. They don't want their name and address out there in the record. So they create an LLC. And in those instances, sometimes the seller of the house doesn't know who's buying the house, or the seller's real estate agent doesn't even know who's buying the house. It's just purchased by an LLC. And there's nothing inherently nefarious about that. There are people who they don't want their information out there. But what the government is concerned about is, where is the money coming from? Where is the purchase money coming from? Is this from money laundering, or is this from some other sort of illegal activity? So the government wants to know who's the real owner of that house. It is one thing if the owner is a Hollywood celebrity, but it's a completely different issue if the owner is a specially designated national and is hiding behind an LLC. So that is a sort of real world example of what this law is all about.
And so it's right there in the title, right? It's a law about transparency and disclosure of information. And so, Naomi, what does the CTA require people and companies to do?
So certain companies will have to file, it's called a beneficial ownership information report. And I'm just going to call it a BOI report, which is what pretty much everybody calls it. And this is a report that is submitted electronically to a division of the Department of Transportation. It's called the Financial Crimes Enforcement Network, or FINCEN. And what it requires is that beginning of January 1 of this year, so January 1, 2024, and because I know people will listen to this episode for years from now, so I want to be specific. Starting January 1, 2024, certain companies have to start filing these reports to FinCEN. And so the reports require basic information, the company name, the address, the tax ID number. But then it starts to get into the weeds a little bit more, and they want to know who is the beneficial owner of this company. And the beneficial owner could be one or more people. And the government is always going to expect there to be at least one beneficial owner. So who is a beneficial owner? Just the words alone, beneficial owner, implicate ownership. Who owns the company? So they want to know who owns, directly or indirectly, at least 25% of the company. So who is a beneficial owner? A beneficial owner is a person who ultimately owns the company at issue. And what is important about this law, and what bothers a lot of people about this law, is that they want to know who is the person, an individual, an actual living, breathing human being. Who owns the company? Who is the ultimate owner? And anybody who owns at least 25% of one of these companies, their name and their information will be reported into the system. So if a company is 100% owned by one person, that's easy. If it's owned by 4 people, that's easy. There are other individuals who are also considered beneficial owners, and those are people who exercise substantial control over the company. So what does that mean? Exercises substantial control. Senior officers will have to be reported. So that would be your president, your CEO, your CFO, your general counsel, your COO. Any senior level officer would basically need to be reported here. But there are other people who might not have that sort of formal title, but who have the same level of control or authority over the company. Those people would be considered beneficial owners too. So the substantial control test, it requires an analysis of the facts. It may be very, very clear and straightforward for some companies. For other companies, it might require a little bit more thought and analysis in terms of who are the true beneficial owners of the company. But there always needs to be at least one, right? Any company, there is at least one person who is in control.
And Naomi, so you could have an individual that has to be reported as a beneficial owner, but they don't have any equity stake if they have substantial influence, given that they serve in a senior role.
Yes, that's right.
That's right. So I think one of there's a lot of interesting overlaps with current government contracting regimes and requirements. And one of the overlaps that I think we see here is, does this definition overlap with the definition of principles that is important in a number of different contexts in government contracting? And we haven't done a thorough analysis on that point, and it'll be interesting. We'll wait for additional guidance, I think, to fully sort that out. But my sense is that this definition is narrower, but it'll be something for contractors to keep in mind, because the scope of individuals who are principals is relevant to, for example, mandatory disclosure obligations. And then the other overlap that I see here is with respect to ownership and the focus on individuals. And it's really rather than an overlap, it's a distinction with the system for award management, which of course contractors have to disclose their immediate owner, and if different, their highest level owner. And there, the owner is necessarily an entity. And so in the system for award management, in that reporting requirement, the focus is on the entity. And so it's interesting here, the reporting requirement is focused exclusively, as you explained, on the individual and the individual owners and their information.
Yes, and it's one of the things that companies are struggling with and people are struggling with is that this sort of information is not, it's not information that they like to give. LLCs are formed because they don't want that higher level information out there. They don't want the individuals' names out there. And this law is really about the person. This is the government wanting to know who are the people.
Right, behind the entities. Absolutely. And so what about, I understand that there's this, the definition of company applicant. How does that work within the obligations and the requirements under the CTA?
So in addition to these BOI reports, including basic information about the company itself, and then information about the beneficial owners, there is also this other category that needs to be included in the report, and that's the company applicant. And that is the individual person who directed or controlled the creation of the company at the Secretary of State. So this might be a paralegal, this might be a lawyer, this might be somebody in-house. This could be the registered agent who created the entity at the Secretary of State. This one is, it's more of an administrative pain to deal with because people need to figure out who is this person or who are these people, but it doesn't necessarily create any concern from a privacy perspective when it comes to these individuals.
Great. Thanks, Naomi. And so we've talked about what the CTA requires of people and companies. What companies, what entities are within the scope of these CTA requirements?
The companies that need to file the BOI reports, these are domestic companies that exist by virtue of filing with a Secretary of State. So a corporation that is created in Delaware or an LLC that's created in New York. In addition, foreign companies that are registered to do business in the US would also qualify. And we'll get into a little bit more, but important for government contractors is that the sort of the first step in the analysis of who needs to file is that it is a company that legally exists in the US. It's, again, a company that is registered at a Secretary of State. So in the government contracts world, there are joint ventures. Some of them are formally created LLCs or entities that are created at a Secretary of State. Others are these so-called paper JVs, which are not legal entities. Those entities that do not legally exist, those entities are not within the purview of this law. But if a joint venture, for example, created an LLC, created it in Delaware, set it up, that joint venture would fall into the scope of this law. So the default rule, and it makes me think of law school when we learned how to read statutes in the first place, is the default rule in terms of who has to report, what companies have to report. I start with everybody has to file unless you don't, right? That's everybody counts except for the people who don't count. So there are a lot of exemptions from the reporting requirements. I think there are some 20 different kinds of companies that are automatically scraped out of this rule. And the companies that are exempted are primarily companies that are already subject to federal regulation and oversight through some sort of formal regime. So a publicly traded company that's registered with the SEC is regulated by the SEC. So that company is going to be exempt. Banks are going to be exempt because there's a whole host of federal regulations that govern how banks operate. So again, remember the policy of this law is about money laundering and illegal activity. So if a company is already heavily regulated by a formal federal entity, it's probably on the exempt list, but you need to read the law and see exactly what the exemptions are. In the government contract space, the most common exemptions are going to be large operating companies and then subsidiaries of large operating companies or other exempt companies. So large operating companies, more or less, is what it sounds like. It's a large company that actually has business operations. So within the scope of this law, a large operating company would be exempt from reporting if it has more than 20 full-time employees, and you can't aggregate your employees among your affiliates. So you have to take your standalone company and say, does this have 20 full-time employees? Does this company have a operating presence at a physical location, a physical office in the United States? And has this company filed a federal tax return in the US for the prior year, and that tax return shows more than $5 million in gross income? And that's based on revenue from only US sources. Unlike the employee rule, you can aggregate the income among consolidated affiliates if those companies file a consolidated tax return. So large operating companies, there are a lot of government contractors that squarely fit into this description, and they are automatically exempt. And so, great. Major exemption.
And so, Naomi, it's probably worth for our audience, which is familiar with the concept of small business concerns and other than small business concerns, i.e. large businesses, this concept is different. And so when we're thinking about a large operating company, or the LOC exception, if you will, under the CTA, it's not the case that if you are other than small under the SBA's rules or an applicable size standard, that you are necessarily qualify as a large operating company. It may be the case, but it's a different standard, it's different tests. And so the standard that you walk through is the one that companies need to apply, and don't get that mixed up with another standard that applies or may apply in determining size status under the SBA rules, including affiliation standards, including employee standards, and the way that you total up receipts over a period of 5 years, for example, is very different than the standard that applies under the CTA.
Yes, that's exactly right. Just because you are not a small business from a government contracts perspective does not automatically mean that you are a large operating company from a CTA perspective, because the CTA, it governs companies all across the country, not just government contractors. And so the rules and the characteristics and the qualifications, they don't sync up.
And Naomi, I was actually surprised that there's an exception for large operating companies. I don't know if this is a fair question or not, but do you have a sense of the policy reason why there's a carve out? And again, it makes sense if you're already reporting. Some of these exceptions make perfect sense. But if you don't fall within one of those other exceptions because there already is information out there, do you have a sense of the policy reason why there's a carve out? I mean, the standard's fairly low in terms of what's considered a large operating company.
I don't have a clear answer to that question, but again, if we're looking at the CTA in terms of what's the purpose, money laundering, tax fraud, criminal activity, my guess is that it's unlikely, or at least the government decided that there's some sort of standard where if you have this many employees and you're generating this much business and you have a physical office in the US, the chances of you using that company for the purpose of engaging in this type of illegal activity is relatively small. That's my guess. At some point, they had to decide, and they must have thought, if we don't have some sort of large operating company exemption, we will just be overwhelmed with filings. I think they are already going to be completely overwhelmed with the amount of data and filings, especially towards the end of this year, that they had to make some sort of exception, and these are the qualifications that they decided would stick.
That's interesting. And that makes a lot, somebody obviously that doesn't follow this the way that you do, it wasn't naturally apparent, but now I'm tracking it because it really underscores the purpose of the law, which is really to weed out and get transparency around smaller entities that aren't true operating companies that have some heft to them. And so we could think of, I could off the top of my head think of other policy reasons why the government would want similar information for larger companies that isn't already available, but those will be different policy reasons than the primary drivers behind this law. I think it's fair to say.
Yes, and then when you think about large operating companies, and there are a lot of companies and who are very happily exempt from this based on conversations that we've had with them, the other exemption that they can avail themselves of is the subsidiary exception. And so a lot of companies have lots of subsidiaries. And if you are, there are some exceptions, but for the most part, in the context, especially in the government contracts perspective, if you are a large operating company and you have subsidiaries where you wholly own and control all of the ownership of those subsidiaries are also excluded. So it's almost a top-down approach, right? If your top entity is exempt, everything below you is also exempt. Now, obviously, there are exceptions. There are many different ways around this, and it requires an analysis of looking at every single subsidiary and really figuring out, is the ownership truly owned and controlled by the large operating company? But this is another way that these smaller operations get exempted from the law.
And that's where counsel comes in to figure out where the exceptions are. And
That's right.
And Naomi, you already mentioned joint ventures, and of course, joint ventures are highly relevant in the government contracting space. Companies form joint ventures for a variety of reasons, including some of those are driven by the same small business programs that were mentioned. Some of that, sometimes it's to consolidate resources. Sometimes it's driven by government procurement specific requirements. So for government contractors that are going to use joint ventures or planning to use joint ventures, what does the CTA mean for them? What are the key issues that they should be thinking about?
I think that companies who use joint ventures are going to fall oftentimes squarely within the scope of the CTA reporting requirements. There will be exceptions, but when I think about how joint ventures for government contractors are set up, arranged, and who the parties tend to be, and what the goal of joint ventures are, and oftentimes the exemptions are going to be problematic. It is less likely that a joint venture is going to fall within an exemption, which is unfortunate, right? You might have a large operating company where all of its subsidiaries are exempt and they're good. They create a joint venture with a small business. That joint venture will probably not be exempt from the reporting requirements. That means that that large operating company that was otherwise exempt from reporting requirements about its owners, that owner information may nevertheless end up being filed in a report with respect to the JV because the JV does not fall within the subsidiary exemption. So if you had a joint venture that was 50% owned by an exempt large operating company and 50% owned by another large exempt operating company, and those two exempt companies, the ownership is 100% in the aggregate, wholly owned, wholly controlled by those two exempt entities, that joint venture would be fine and would not have to file with the CTA. But that's not how it works, right? We often see larger companies and smaller companies forming a joint venture. And again, these are joint ventures that legally exist. So not these paper JVs. This is an LLC that has been formed in Delaware or New York or wherever, right? But that joint venture, if it's 80% owned by an exempt company, but 20% owned by a company that's not exempt, that joint venture suddenly is going to need to report. And that means that you, right, go up the chain, up the ownership chain, and all of a sudden that 80% owner that was on its own exempt is now having to dig through its ownership records and figure out who are the beneficial owners, how do we have to report, what information do we have to provide. So I think that it's worthwhile for companies who are setting up joint ventures in this space to give thought to this and the implications when they are setting up the joint ventures. But as a practical matter, the ability to avoid reporting out under the CTA is not going to align with the needs and the purpose of the joint venture itself. And this is where we are really hearing from folks about how this law doesn't really work, or it's not practical. Because if a company, for example, is 80% owned by an exempt entity, should the government really care about that 20% owner? What are the chances that that 20% owner is nefarious and engaging in illegal activity, right? But because of the way that the law reads and the way that the guidance works right now, there are going to be a lot of joint ventures that are going to have to report to the CTA. And it's a bit unfair. And I think that there is a lot of space in the law and guidance for this to grow and evolve over time. This law, there is guidance that comes out every couple of months. People submit questions to the government responds, tries to give a little bit of guidance. And I think that over time, we will start to see guidance that starts excluding certain types of entities or providing guidance and saying, no, actually, you don't have to report that, or maybe just on this circumstance, because it's going to become unwieldy. And again, if the purpose of the law is to prevent this illegal activity, the sort of scenarios that you see, at least in the government contracting world, that's not what the law is about. And it's going to just create more work for the companies, for the joint ventures, and then also on the government side, who are receiving all of this information and trying to figure out what to do with it.
That's very helpful, Naomi. Thanks. And it occurs to me that it's probably a sliver or a relatively small percentage of the joint ventures that are formed or operating in the government contract space, but there probably are some that would qualify under the large operating company exemption if they are populated. There are JVs that are formed and populated to perform longer term contracts. And so I think in some instances you might have some that would qualify, but it seems like that would be the exception to the general rule. So we've got all this information that's being disclosed by covered companies, and the government is going to have that information. Who has access to this database where all this information is stored?
So we get a lot of questions about this because this database, setting aside information about a company's name and address and tax ID number, right? We're talking about owners and people, and the law is really getting at people. And although the information on the individuals is quite limited, it's name, address, it's not a laundry list of personal or private information, but it's still personal information that's going to be somewhere. So the information, it's stored in a database, and it's considered sensitive information. It's going to be kept confidential by the government, but there is going to be access made available to government authorities and certain financial institutions. So the law says that the types of entities that will have access to this data would be federal agencies who are engaged in, national security, intelligence, law enforcement, and all of that makes sense, right? Again, the purpose of the law is money laundering, illegal activity. So of course, these types of enforcement agencies are going to have access. Additionally, financial institutions, and the goal here is to, potentially streamline diligence requirements when you're talking about a bank doing know your customer diligence and making sure that its customer is who they say it is, and that the bank itself is not inadvertently shuttling money around back and forth for money laundering purposes. So this information will be kept in a secure database, and hopefully it stays secure, right? Obviously, there are people who are concerned, with hacking or anything else that could happen, but the reality is that the information will be in this centralized database that's controlled by the Department of Treasury.
So Naomi, this information, what is the name? Is there a system or is there a name for the database?
Yes, it's called BOSS, which stands for the Beneficial Ownership Secure System, and it's maintained by FINCEN, which is part of the Department of Treasury, and it's online. And I have not personally gone in and fiddled around with it, but the person would go in, or the company would go in and insert the information there.
Okay, interesting. So we have yet another government information system. It seems like the idea is the information will not be readily available outside the government, and there will be restrictions on access inside the government. We're familiar, there are other systems, including past performance systems, where there's access within the government, but not outside the government. Also, certain information that's in the system for award management is not available to the public as well. It'll be interesting to see how broadly the exceptions on dissemination related to law enforcement and national security are applied. You could see situations where the information is relied upon by agencies in evaluating proposals to identify, for instance, whether there are perceived conflicts due to ownership interests of owners of companies, entities that are involved in government contracts. When do companies have to report?
So the good news, in part, is that for companies that were created before January 1, 2024, they have all of this year to get their ducks in a row and do all of this analysis and to file the report, the BOI report, into the BOSS system. So that's good. For entities that were created or are created this year in 2024, they have 90 days to file a report. So for companies that are creating entities now, or for people who are creating entities now this year, this law is something that they need to be thinking about right away, because they only have 90 days to comply. Now, again, if you're exempt, and that's great, but you have 90 days. And then starting next year in 2025, that is shortened to 30 days. And I'm sure the rationale is everybody's had a year to sit down and digest and get comfortable with this law. So starting in 2025, you only have 30 days. So what we're seeing what we are seeing right now are companies starting to make plans and starting to do the analysis and think about it for companies and entities that existed prior to this year, and they're starting to do the work. As a practical matter, they probably won't actually start filing until towards the end of the year. And that's because once you file, if there are certain changes to the information, if your beneficial owner changes, for example, you have to update that information within 30 days. So it makes more sense to wait, if you can, right, for companies that were created prior to this year, to not actually file until towards the end of the year, because otherwise they're going to start to have ongoing obligations for the rest of this year. But what is starting to happen now, of course, is it's March 2024. Companies are being created every day. LLCs are being created, corporations are being created, and people need to be thinking right now, okay, the clock is ticking. I have 90 days to figure this out with respect to this company.
And what are the penalties? Say a company doesn't report. Are there any penalties that are set forth in the law?
Yes, there are penalties. And interestingly, the penalties focus more on willfulness and as opposed to inadvertent error. But there are penalties, and the civil penalties are $500 a day, up to $10,000. And there are also criminal penalties. And so you can imagine the criminal penalties would be reserved in, I'm sure, extreme cases. But there are criminal penalties of up to 2 years imprisonment. So it is something that people need to take seriously. And again, for government contractors, it's a new regime that is going to not be a lot of fun to comply with, but it is going to be yet another law, yet another regime that government contractors are going to have to comply with. But outside of this context, you think about any small business out there, or any person who creates an LLC to buy a piece of property that, for whatever reason, it doesn't have to be a celebrity, right? It could just be, I'm a person who created an LLC for my kids or something like that, and I want to buy a house. So this law is very all-encompassing, and the penalties, I think, are, again, it's not exclusively, but it really focuses on malicious intent and intentionally evading filing and complying with this law.
And it's interesting, somebody that focuses on government contracting, as you do as well, we're constantly focused on the potential for False Claims Act liability and double and triple the government's damages. So when you hear about the financial penalty, the civil penalty is $10,000. Now, of course, there is for willful issues, there's potential imprisonment, but the civil penalties are fairly modest. So it will be interesting, though, to see. I think you certainly could have situations where, if there is an egregious violation of these requirements, that could be a basis for suspension and debarment of a government contractor. So they're ineligible for receipt of additional awards during the period in which they're suspended or debarred. And you could conceivably have agencies that fold this into their requirements, compliance with the CTA, and say, if there've been any non-compliance, that could be a basis. That could be an explicit responsibility criteria, things like that. So we'll see how that plays out, and how agencies, if they address this in their own requirements going forward. So Naomi, this has been a great overview. Perhaps to wrap it up, and I think as we've gone through it, you've touched on this to an extent, but perhaps a final question: what should companies be doing now? Say they're a company that has existed, they were registered before January 1st of this year, and so they've got some time. What should they be doing now to prepare?
So the first step, right, is be aware that this law exists. So anybody who's listening to this podcast is already one step ahead of the game, right? They know the law exists. Companies should be establishing an internal process to track their companies and the information. So for example, coming up with an internal process of, if we have a change in officer, or if our ownership changes, there needs to be some sort of process for that information to be identified and the proper person internally notified to file an updated report into the BOSS system. So companies should be doing internal reviews. Or if we're talking about one small business, that should be relatively easy to track. But you can imagine that there are companies that have in their ownership chain hundreds of companies, potentially subsidiaries in all sorts of places that may or may not qualify for an exemption here. So for some companies, especially if you're talking about companies that are backed by private equity firms, it can be really complicated to do this analysis. And so it's worth earlier rather than later sitting down and figuring out what the obligations are going to be and how this is going to be managed. But I do not recommend that companies wait until the end of the year to figure this out, right? I think it makes sense to, if you fall within the pre-2024 scope of things, I think it makes sense potentially to wait towards the end of the year to actually make the filings. But companies need to now be figuring out what that process is going to be, because what's going to happen, right? It's just like filing for your taxes in April. There's going to be a scramble at the end of the year where everybody's, oh my God, this deadline's coming up and we need to comply. And they haven't done the legwork. So that legwork needs to be happening now. And there are lawyers, right, who can help manage this process, help do the factual analysis and figure out who's the beneficial owner, who's the company applicant and all of that. But people should not be waiting until the end of the year. And especially if there are companies who are active now or people now who are creating companies this year, your obligations start now. So these processes need to be put into place.
Great, Naomi. That's very helpful. In closing, it sounds like there's a lot of issues that are likely to evolve from here with additional guidance, perhaps updated regulations. What's the best way for companies to keep on top of these requirements as they evolve?
So to get the guidance directly from the government, there is a website, FINCEN.gov, and that website has all of the information that we discussed more or less, plus their official guidance, the official statute, and all of that language is there. The website is updated from time to time with Q&A based on questions that the government receives about this and discrete factual patterns. It's very similar to what you would see on the SEC website. So there is this resource available, and the government tries to make it very accessible to people to look at and get that information. But of course, additionally, Arnold and Porter, we are tracking this as well, and we have a website, and we have articles and information, and we update that information as well to help provide guidance to people who are looking for perhaps a more layperson explanation of the guidance and the law surrounding these new requirements of the CTA.
And we will put that in the show notes. So Naomi, thank you so much for coming on the podcast and walking us through the Corporate Transparency Act. This has been very great, very helpful.
Thank you. Very, very happy to have joined you.
Thanks again to Mike and Naomi for that great overview of the CTA. You can find links to the firm's analysis in our show notes. And that's it for this episode of Bona Fide Needs. To keep up with government contracting and legal developments every day, subscribe to PubK at pubkgroup.com. For additional expert analysis and insights, you can find multiple timely and informative blogs at arnoldporter.com. Thanks for listening. You can find Bona Fide Needs on your favorite podcast platform, including Apple Podcasts, Spotify, Amazon, and YouTube. You can help us reach more listeners by liking, subscribing, or leaving a review. For Arnold and Porter and the PubK Group, one last time, this is Bill Olver, signing off. Bona Fide Needs is a joint production of and copyright Arnold and Porter, providing legal advice and thought leadership for government contractors, and the PubK Group, publisher of daily news and insights for government contractors and their counsel. This podcast is produced by Bill Olver and Tina Chen.